Hello, welcome to Bear Paw Media and Education's Public Legal Education webinar series. My name is Nadine Callahoo Hansen. Bear Paw Media and Education is a department of Native Counseling Services of Alberta, and our primary goals are to make public legal education understandable, accessible, and affordable for Indigenous people. We at Bear Paw are not lawyers, although we do endeavor to make sure that this information is correct and current to the best of our abilities and is edited by lawyers. This webinar contains legal information only. Laws change with elections and societal values, so this information is designed to be general in nature and may not apply to your specific situation. It may be necessary for you to consult a lawyer for legal advice to assist you. For more information, you can look at our website at bearpawlegalresources.ca or follow us on social media at bearpawlegal. Today, we're going to be discussing what our legal rights and responsibilities are as parents. I'm not here to give people lessons on how to be a better parent. We are solely focusing on what the law dictates about what parents' legal rights and responsibilities are. So before we begin, I'd like to acknowledge that we are on Treaty 6 land, which is home of the Métis, Cree, Saulteaux, and Blackfoot people. So let's begin with starting our PowerPoint. So the first thing you need to know is you're pregnant. Surprise! Came as a bit of a shock. What are your legal rights and responsibilities to that child? First of all, during pregnancy, discrimination is absolutely not allowed. A woman who is pregnant cannot be refused employment, services, or residence based on their pregnant status. If for whatever reason someone believes that they are being refused services, employment, or residence based on any protected status, who you are, what you are, those kinds of things, including pregnancy, you can contact the Alberta Human Rights Commission and file a complaint, and they will investigate for free. Now, there is a bit of a gray area in this particular section, and that is adult-only facilities. If somebody moves into an adult-only building and they've signed a contract stating that they know that it is an adult-only building, once they become pregnant and give birth, they can be asked to vacate. This has not been challenged in Alberta to the best of my knowledge. And so although it may be grounds for discrimination, it has not yet been challenged, or I should say not won in court, that the signed contract would certainly supersede the discrimination stature. But things change all the time. During the pregnancy, the father has absolutely no legal rights whatsoever to be involved with the pregnancy without the consent of the mother. In Canada, pregnancy is considered an extension of mom's body, and so the unborn fetus possesses no legal rights whatsoever. And so what that means to everyday terms is that should dad decide that they want more involvement and mom doesn't want it, they can't challenge it in court because the courts don't have any jurisdiction to make a ruling over a non-person. Where we see this lack of law as well is if mom happens to be involved in some very risky behavior, risky for the unborn fetus, and they may get reported to Children's Services. Children's Services as well has no power to get involved until the baby is actually born and separated from mom's body. Typically, what we see here in these situations is Children's Services will actually open a file and they will put that person on notice at the hospital. I'd like to think that common sense prevails somewhere in the middle, but who knows where our laws may change according to society's values. Once the baby's born, parents have 10 days after the baby's birth to name and register them. I've never known anybody to be criminally charged under the Vital Statistics Act for failing to name their child. However, it does become problematic later in life for that child. So when I was a court worker back in another life, I would assist elders who wanted to apply for their seniors' old age pensions, but because they were never registered, didn't possess a birth certificate, that became problematic because they had to be able to prove their age. And so we would have to try and locate a baptismal record. If we were lucky, we would find one of those. If we weren't lucky, we would then have to find somebody who was still alive that could remember when that person was born. And we would have to complete a statutory declaration with that other person declaring what they remembered about the year that that person was born. And so in my experience, Indigenous people weren't really weren't great at remembering specific dates, times, that kind of thing. So I've completed statutory declarations that would say things like, I remember it was the harvest time of 1929 when Joe Blow was born. And so I would turn to my client and say, okay, so pick a time somewhere in August, September, October, harvest time. What date feels good to you? Because that's going to be your official birth date from now on, that date of 1929. And we would file that with the Alberta Vital Statistics and the courts and make it official. So it does become very problematic later on in life. As well, until recently, Indigenous Services Canada, if a child is entitled to treaty status through DAD, at least initially, the only thing that Indigenous Services Canada will look at is the birth records. And as long as DAD is listed, then of course the treaty status will go forth. This becomes as well problematic if DAD is not listed on the birth certificate. But of late, particularly with Bill S3, a topic for another day, Indigenous Services Canada has certainly expanded that scope and now will look at a child's heritage through other members of the family. However, it does still become problematic. So if the child is entitled to treaty status through DAD, the best course of action is always make sure DAD is on the birth certificate. All parents have a legal duty to provide proper care for their children. In most cases, when parents fail to provide proper care, Children's Services gets involved. However, in extreme cases, parents can be criminally charged for failing to provide the necessaries of life and can be fined or even put in jail for a very long time. Almost always when this situation happens, when the extremes happen, it'll also hit global news. Just recently, within the last few years, we've seen, and it's still in the appeal process, in fact, where parents in Calgary failed to bring their child to receive medical attention, and the child died as a result. They thought it was flu, and it turned out to be a form of meningitis, I believe. Don't quote me on that one. So the parents were criminally charged, and they were actually found guilty for failing to provide the necessaries of life. The parents are still appealing that, and we'll see where that turns out. Parents really need to keep up to date or current on the laws of the land for today. Um, um, One situation that commonly happens every summer, somewhere on multiple occasions actually throughout the world, is parents are criminally charged for failing to provide the necessaries of life for their children because they've left their children in hot cars, in hot weather. This also applies in extreme cold weather as well. But it is particularly dangerous in warm weather. And this is something that parents commonly did 20, 30, 40 years ago. I like to share, because it's interesting, call it a little bit of Trivial Pursuit, is that historically, children in Canada were not protected by law until they were finally protected under the SPCA laws. Yes, let me repeat that. The first laws to protect Canada's children were under the SPCA laws. We had laws to protect our animals long before we did our children. And again, I think that that really is a direct reflection of society's values. And so when we look at our values 100 or 200 years ago, it was far more costly. It was a much more significant loss to a family to lose the family cow or to have horses or cattle stolen than to lose a child. Thank goodness society's values have changed over the course of time. Throughout this workshop, we're going to talk a bit about how our laws around parenting have changed according to society's values. So, all parents have a legal duty to provide proper care for their children. I'm not going to go much more into that because we are also doing a workshop on the ABCs of the Child, Youth, and Family Enhancement Act. So we'll get more into this whole aspect of providing proper care in that workshop. Section 43 of the Criminal Code states that every school teacher, parent, or person standing in the place of a parent is justified in using force by way of correction toward a pupil or child, as the case may be, who is under his care if the force does not exceed what is reasonable under the circumstances. Clear as mud, right? You wonder why our people are not really certain about what their legal rights are. It's because our laws are written very much like this. So in plain English, what this means is that from a legal perspective, anybody that has care and control over a child has the right to use force to correct behavior, as long as it doesn't exceed what is reasonable. However, there are policies in place that through the Alberta Education Act that state that corporal punishment will not be tolerated. So teachers, although they legally, according to the criminal code, would be able to use force to correct a child's behavior, the Alberta Education Act says it's not acceptable. As well, foster parents, according to the Child, Youth, and Family Enhancement Act, foster parents as well cannot use corporal punishment. And in fact, the department provides quite extensive training on nonviolent restraints. So being able to control a child without using violent or corporal punishment. So that's what the law says. However, there's a huge difference between legal, moral, and ethical. So I'm here to tell you that legally, parents are able to use corporal punishment. However, again, in this section, we have two very strong lobby groups that are fighting to change our laws to reflect their own personal biases. So popular opinion one, violence begets violence, meaning all spanking should be outlawed because the only value it does is it teaches children to be violent. Okay. And popular opinion number two, spare the rod, spoil the child. These are my children. No one's going to tell me how I can and can't parent them. Again, hopefully common sense prevails somewhere in the middle. Before I get into what we as Indigenous people historically and culturally have believed about parenting and particularly discipline, I would like to talk about the boundaries around Section 43 that the Supreme Court of Canada put in place. So even though legally, parents are able to spank their children, the Supreme Court of Canada states never, and I repeat, never, in the face and head area. Why? Because when you look in the mirror, you don't look at your arm and you go, yeah, that's Nadine. No, people closely associate who they are, their identity, with their head and face. And so it's the belief that when somebody strikes a child in the head and face, you're causing more trauma than if you were to slap them on the hand or give them a swat on the butt. So never in the head and face. And it's important that people are aware of that because we need to look at our own parenting beliefs and styles that maybe we grew up with. So when I was growing up, it was common practice to slap a child across the mouth for swearing. If you were to do that now, you would be criminally charged for assaulting a minor. And judges would have no choice but to find you guilty because you had struck that child in the face and head area. So it's important that we know what the current laws are and reflect on what our parenting styles are according to those new laws. As well, never with an object, never with an object. How many of you were spanked with a hairbrush or a belt or a wooden stick or better, here's a good one. How many of you were sent out to choose your own willow stick? Oh yeah, fun stuff. And so common practices, all not that long ago, are now absolutely against the law. And so although it is legal to spank a child, you would have to do it with an open hand, not a closed fist, never with an object. Never under the age of 2. Why? Because a child needs to be able to understand, comprehend why they're being hit. Children under 2, the only thing that they know is that they're being hit. They cannot make that connection of why they're being hit. And so never under the age of 2, also never over the age of 12. Because teenagers, although you might get some short-term compliance, in the long run, you're just creating a rebellious monster. And so the long-term effects or results don't warrant it. So never under 2, never over 12, and never in the head and face, and never with an object. And as well, never using excessive force. So again, open hand, and if it's leaving marks or bruises, that's excessive and it's child abuse. All right, and it always has to be for the purpose of correcting behavior, and the child needs to be able to understand that or make that connection. So that being said, I'd like to talk about the traditional Indigenous parenting, because from a cultural or traditional perspective, Indigenous people never believed in corporal punishment. And so I'd like to put the PowerPoint on hold just for a moment. And what I'd like to do is share our video. Okay.
Bringing a life into this world, traditionally, for our people, was seen as something sacred.
There's ceremonies, and they all relate to discipline.
The act of parenting and the act of discipline, that was seen as something sacred as well.
Traditionally, children are at the center of the circle, so there was a whole system that surrounded them and was part of their discipline.
And so they're prepared at a really young age. It's not wait until they're 13. It's like you've got to start thinking about taking care of yourself.
Our traditional values as First Nations people were always respect, honesty, kindness, and sharing. And that's the approach we took when it came to parenting.
It takes a community to raise a child. The child already has a mindset that the responsibility is all around them, and it's not just within the boundary of their teepee or their home.
When we bring a life into this world, it's not our life to keep. Well, we're only loaned our children. It's our belief from the Creator.
Our whole way of life at one time was one art form. Today, it's a little different. We are a lot less connected to a lot of those practices.
You know, none of us have perfect children, and none of us are perfect as parents. We are all human, and, you know, we all need help.
We'll set up at this table. We got to tie on a hook, right? You need a hook.
Yeah.
My name is Lana. I myself am a young parent. I have a 2-year-old daughter. Her name is Candida. She means the world to me. She's my everything. Everything I do is, you know, for her. You know, maybe the way I discipline her is, you know, trying to talk to her, but you know, sometimes she's in that age where she doesn't, you know the difference. I've learned, I think you have to kind of, you know, be there in the moment. But the question is what do you do? Because sometimes, like, I don't know. I really don't know.
And the biggest reason in our reserve why we have a lot of parents that don't know how to parent is because their parents weren't around. And so they didn't know how to parent their children, and now their children are not parenting their own children.
Pull. Grab it. Yay!
You know, a lot of parents that are kind of entering into parenthood, they're doing so being very ill-equipped, kind of being thrown into the position and coming from histories themselves that may have been, really challenging and difficult.
It wasn't us who brought in corporal punishment. That came with Europeans. It was introduced to us through the residential school system. It was introduced to us, through our own public school system, all these places that we attended.
There was intense structure, and things were timed at a certain time. There wasn't that love and nurturing and attention given to each child. And so that has a huge impact on how that child is raised and how then they raise children, right? So then it becomes that historical impact.
My mother grew up in a residential school. My father, fortunately, didn't have as much impact. So I grew up in terms of discipline with very, very contrast methods. My father, who was very gentle and kind in his methods, and my mother, who was very dominant and very stern. The fact that he would yell at me had more impact than my mom using a willow.
If we misbehaved, we got the willow. But our parents who inflicted that upon us came from a residential school or a public school system that used the same thing on them. So that was learned behavior. They felt to be a good parent, that's what you did.
I looked at both methods. I looked at the physical, abrupt way of trying to stop a behavior. And then I looked at, when I think about my dad, and I talked about my dad and how he disciplined me. Because of the two methods, many family members in my family became confused. What's the best method? You want to be harsh, or you want to be gentle, or you want to show by example.
It is only now, after all this time, that suddenly everything changes. And they say it's against the law to hit your child. Well, for us, it's always been against the law. Against God's law, our grandfather law.
Traditionally, the coming-of-age ceremony was used to teach self-discipline. When a young boy was transitioning into a man, this custom would involve fasting for up to 4 days.
And for you to find yourself.
This journey was necessary to become balanced within oneself.
I think that what's important is that we pass on the fundamental principles of the traditions that we have.
Jane, we're going to set you up for the night here. We're going to get some smudge set up for you in the fire.
Okay.
Because of the harshness in which we lived, for that child to survive, for that child to be a part of the community was a great gift.
How we work with that change is what's relevant. And for the Aboriginal people, what we used to do is we used to say, okay, now your body's changing, your mind's changing, you're thinking differently. And that's where you would have your rites of passage coming in.
We start preparing them for the next level of life. That is that coming of age ceremony when they become an adult. And all their teachings, all the help and support is guided towards that. Because we needed people in our community who knew where they belonged, where they fit in, what they could contribute.
When the young men get to experience that, and then they find what it is they have to do with their life, because then they, whether you want to call it the spirits or whether in the contemporary society they want to call it digging deep inside yourself, finding that, most inner sense of yourself, it's the same thing.
Disciplining ourselves and understanding the Creator's law for us, and subjecting ourselves to the harshness of learning through suffering also. A child also needed to understand the physical, the mental, the spiritual, and the cultural aspect of their well-being.
My belief is if we implement that method for the young men, if we bring that method back into a practice today, the methods of forcefulness is not necessary. So when we talk about the two different methods, we have this method that, and it's harsh. It's harsh to be out there fasting. It's harsh to be out there and by yourself in the bush. All of that is just as harsh, and might even choose, the willow over that. And I guarantee you, many have said, I'd rather get a willow, because it's a couple times I have to deal with the pain, whereas this is I have to deal with my own person. And that's the significant difference in our traditions. You deal with your own person when you're there by yourself.
So our way of doing things is far different than what has taken place since contact.
There are many stories that are represented in our ways. Through our ways, we pass on our knowledge, and through this knowledge, we become connected to our traditions that help create a path for our children to follow. Discipline comes in many forms, and we must first pass on the traditions so that the discipline has a healthy base in which to grow and foster a child's direction in life. We must teach through example and become healthy role models through positive interaction and involvement.
So when we become parents, we're kind of learning as we go. We're having to relearn a lot of things, and also having to reparent ourselves in the process.
When you live within a system that has taken all of this away for 7 to 10 generations, and it's sad, but frustration plays a big role in striking out. It does not justify, hitting your child, but it's a behavior, and behaviors can change.
No. Stop that. Okay? At that moment, probably I wish I had, a bit more patience, but then I think too is, I'm with her every day. I guess I have to kind of swallow my pride in seeing what I can do to kind of diffuse the situation before it gets out of hand.
Physical punishment is whenever we use physical force to try to punish in any way or direct someone. It's also referred to as corporal punishment. So examples of physical punishment would be slapping, spanking, pushing, shaking, pinching, anything that involves a physical form of trying to direct a child or youth.
What boundaries did the Supreme Court set for physically disciplining children? The Supreme Court of Canada stated that force must be intended to educate or correct the child. Force used must be to restrain, control, or express disapproval of the actual behavior. The child must be capable of benefiting from the discipline. In other words, factors such as a child's age and ability will influence how the child learns from the use of force. The force must be reasonable under the circumstances and not offend society's view of decency. The court interpreted reasonable force as minor corrective force, which is short-lived and not harmful.
What do you want in your sandwich? Do you want some meat? Yeah?
Well, discipline is a very important part of parenting. I think basically discipline is how we work to influence and support and guide our children to be self-disciplined themselves. So whenever we influence and we teach our children how to be competent and self-directed individuals, that's discipline.
Yeah? You like it?
All children need guidance from their parents, including how we want them to behave. This guidance is what we call discipline. Children need time to learn what they should do and should not do. They learn by watching their parents and others, by hearing clear instructions, and by getting praise and encouragement for their efforts. Discipline teaches children responsibility, self-control, and right from wrong. It raises the child's self-esteem, encourages the child to do better, and strengthens the parent-child bond.
People don't think that children like structure, that they like to be bad, but actually children thrive with structure. And children, it makes them feel like they're more noticed, I think, if they have some discipline in their life.
Well, I think when it comes to discipline, a lot of care and time needs to be thought out every day. I mean, that's the challenge of being a parent, is that you're really having to think of things ahead of time, and you're having to think of multiple things at the same time when it comes to children and what their needs are.
I'm big on taking care of the caregiver, and I talk to the caregivers, the parents, about respect for themselves, first of all. You have to have respect for yourself. You have to love yourself in order to love and discipline your children or love anybody else.
Discipline is really, if you want to use a different word, is really teaching. And unfortunately, people are getting the two mixed up. They think punishment, and more specifically physical punishment, verbal punishment, are discipline, when in fact that's not the case.
What limits did the court set on reasonable force? The court found that the following is not reasonable. Hitting a child under 2 years of age. It is wrong and harmful because spanking has no value with very young children and can destroy a child's sense of security and self-esteem. Children under 2 do not have the ability to understand why someone is spanking them. Corporal punishment of teenagers. It is not helpful and potentially harmful to use force on teenagers because it achieves only short-term obedience. It may ultimately alienate the youth and promote aggressive or antisocial behavior. Using objects to discipline a child, such as belts or rulers. This is potentially harmful both physically and emotionally. Slaps or blows to the head. Degrading or inhumane treatment. Corporal punishment which causes injury. Causing harm is child abuse.
You think you're gonna catch a fish? There's times where, I've lost control of the situation, and I let anger get the better of me. And did I feel regretful after? Absolutely. Did I feel like I lost something? Absolutely. I felt like I lost maybe their trust, and that was the understanding back in the day for our elders. They knew that you take something away when you hit a child, you take something away from them, because that spirit is so pure, because that child is so in tune and so in balance still with their nature. It's when you strike that child, or you get angry, or you raise your voice, and that's something I was taught as well. As traditionally, is we have a word, and that's pastawan, and what pastawan means is to go against the laws of nature.
Younger children don't have the cognitive abilities and the verbal skills to express themselves. So just again, as a parent, being really mindful of that you have to keep things very simple when you're talking to them, say it to them in a way that they'll understand, being calm yourself, calm and firm and loving, and and if you can't be in that moment of frustration, taking time yourself. These things don't always have to happen right away, immediately. If you can take some time for yourself to cool down and then go back, then that's the best way to handle that for a parent.
Look, you see, you connect these dots together.
The most rapid brain development happens before the age of 5. And so all of the maps in the brain are getting settled at that time. But not to say that, they're a lost cause after the age 5, because of course developmentally there are needs that need to be met throughout as they grow up. But definitely, being really mindful, particularly of those early years, making sure there's lots of hugs, a lot of nurture, lots of safety, consistency.
Give mommy a hug.
Yeah, baby hug.
I love you.
In terms of consequences for disrespectful behavior, I think if you can try to keep it as natural as possible, and what that means is, if a child misbehaves, like let's say coloring on the walls, you know, so a natural consequence for that would be taking the crayons away for that day, right? So it's what the child actually used and taking that away, versus, let's say, taking away that child's dessert for that evening, because it's kind of not related to the behavior. So wanting to keep it as natural as possible, again, to encourage the learning of that. And so the child can draw those parallels between what they did and what the consequence was.
I really preach choice and consequences. I also preach the when and then rule. And when and then is not really traditional, but it works really well. So if you have a little child who's, let's say, a biter, and then you always give them ice cream, and say, when you quit biting, then you can have some ice cream, and stick to it.
Candida, don't do that. Okay?
I think timeouts are basically an opportunity to remove a child from a situation that is intensely emotional for some reason, and it's just giving them a time to just settle, to cool down, and you know, giving them the opportunity to really think about maybe what happened and what, you know, what went wrong. And you want to make sure that attention is made to time. You know, I know some parents even put a timer on. I think the recommendation is 1 minute per age. So timeout is not a chance for you to get rid of your child in a moment of frustration, just kind of leave them there until you feel better. It needs to be an opportunity just for the child to settle their emotions, so that way you can communicate with them in an age-appropriate way of what happened. You know, talk to them about what went wrong, and talk to them about how they could have dealt with it differently. So again, using that as an opportunity to teach.
It's a beautiful day, eh? Not too hot, not too cold.
Discipline is going to be different for your teenager, because at that stage they're starting to have the cognitive abilities in their brain to start putting things together. They're trying to figure out and develop their own opinions and their values and how they see the world. And as a parent, your role then becomes one of encouraging that to develop their own self-direction. And you still do need guidelines, you still need limits, you need rules, but that needs to be discussed with them. And even asking for their feedback. You know, what do you think of this rule, or what do you think of that? Do you think it's fair?
Okay, we'll watch what I'm doing. Yeah. So you'll know what to do.
Raising a teenager is very different, and you also have to be mindful of that power dynamic. If you get into a place of, oh, my teenager should know better, you know, they're doing this just to get me, they're doing this to manipulate me, you're setting yourself up for a power struggle, which doesn't help anyone.
Okay, here you go, lefty. Okay, James, make sure everything is always good on a bridle, because this is your steering wheel.
Teenage brains, young adult brains are so full. Hormonally, things are happening. If you think about them going into this world as adults, you know, there's so much change happening. Their brains are so full that they forget, or they don't think about the little things, like not leaving food in the room, you know, locking the door when they leave. It's like us, you know, when we're on a distracted day and we put milk in the cupboard and cereal in the fridge. That's the teenage brain, right? They're just so much going on for them. As a parent and a caregiver, you will never be your child's or teenager's friend. Never. Those two things don't go hand in hand, because a friendship has very different boundaries around it. And when you are a parent or a caregiver, you do need to be more mindful of boundaries. You don't want to be sharing personal or inappropriate things with your child and your youth. So that means that you're not their friend, right? Because it can't be reciprocated in that way. So that's a really important point.
You always got to do this. It's not right to let a horse sweat like that and just let him go. It's got to get the sweat off.
It's not a good idea to always rescue our children from things that they do need to learn on their own, because again, we're wanting to model that responsibility, that accountability, right, for our children. And sometimes they're going to make mistakes. Sometimes they're going to let the ball drop and they're going to get in trouble, or they're going to have to face certain consequences, and that's all part of learning. And so as parents, caregivers, we need to be there with them as they go through that, not to fix it for them, not to rescue them, but just to guide them along that process of needing to deal with the consequences that they have to face.
Keisha, we're going to make some bannock here and cook it outside. I usually put one egg in here to make it tastier. So there's the egg.
Every child, every youth, and not just children or youth, all of us, we just want to know, do you love me? Do you accept me? Am I important to you? Do you notice me? Do you see me? So are you taking the time to get to know how their day went? Are you taking the time to see, look at their schoolwork or look at their drawings, to go watch them during a sports event?
Okay, start kneading it and you'll start feeling that it's getting together and getting more soft.
There are going to be so many influences out there, so many external things that are happening in a developing child's life, in a youth's life, and so I think, but what's most important in terms of influence will come back to the parent, will come back to the primary caregiver for that child. So how that person is living their life, are they disciplined to make sure that they're not watching too much TV? Are they disciplined to make sure that they're turning off their smartphones during dinner time? Are they, disciplined to spend that time, that quality time with their children and just playing with them and being with them, because they are ultimately the most important role model for that child and how they live their life, how they deal with frustration, how they deal with conflict, how they deal with their own anger. As a parent and a caregiver, there are always going to be eyes on you, always, even when you think they're not watching, they're watching.
Thank you, Kokum, for teaching me that.
Oh, it was a pleasure. Don't forget.
I will.
Always cook this and remember. Enjoy.
You did a good job dancing here today. Look at me. That is who you are. Okay? That's who you'll always be.
So I think it's really, really important to trace our roots and to know where we come from and to know and understand why our parents or grandparents did things the way that they did, so that it helps us to either decide whether or not we want to keep those things or change those things.
It's taken us a long time to hit the dysfunction that we've hit to where we are today, where there's been a total collapse in us as a people. But we are a strong people, and we are coming back, and there is hope. And with that hope and that strength, we can do it.
We as a society are always changing and evolving, and so is the law. We must remain informed, and as parents, we are always learning. All parents need ideas and support. Remember, nobody's perfect. Places to look for support with parenting: a family doctor or nurse, local public health departments, child care centers, family resource centers, child and family service agencies, parenting programs, Native Friendship Centers, First Nations, Métis, and Inuit organizations, multicultural or newcomer centers.
I love that video. All of our resources are available on our website, www.bearpawlegalresources.ca. Not only will you be able to find this video, but we have lots of resources regarding family law. We have a booklet on everything that you've heard around parenting and discipline. We have wallet cards on private guardianship orders. Oh, we'll get into it. But anyway, tons of resources around family law on that website. So go check it out. Okay. So sometimes the identity of the child's father is an issue. This is called paternity. For example, the mother might believe a certain person is the child's father, while her ex-partner might believe that he's the father of the child, or the person that she believes is the father of the child may deny it. In some cases, the law will presume or declare that an individual is the child's father, unless he can prove that he's not. The Family Law Act lists a number of circumstances in which a man will be presumed to be the father of the child. They include if he was married to the mother of the child at the time of the birth of the child, he was married to the mother of the child within 300 days before the birth of the child, so almost a full year. He marries the mother after the child is born and acknowledges that he is the natural father. He was living with the mother of the child for 12 consecutive months before the child was born and acknowledges that he's the father. He and the mother have signed a statutory declaration stating that he is the natural father of the child. If he has signed the birth registration form, so the birth certificate, or the court has found him to be the father of the child. If someone is named as the father of the child in any court application, the responsibility lies with the person to prove that they are not the father, whether or not his name is on the birth registration or not. And so what that means is that if a person is named, then they can always arrange for DNA testing at their own expense. And of course, much of our lab work stuff in Alberta is privatized. And so this is one of those where, depending on where you are in Alberta, could cost you anywhere from about $600 to, $1,500 or not, or thereabouts. But compared to spending 18 plus years of child support on a child that may or may not be yours, it might be worth the investment. If the court, DNA testing, which may be used in court to prove paternity, can be expensive. For example, the court may order the person denying paternity to pay for the test, or at least part of it. If the mother is on social assistance and the tests do not prove that they are the father, social assistance may reimburse them for the cost as well. So keep that in mind as well. Also, when we're talking about presumed parentage, ladies, we are not off the hook here either. Now, of course, there is a free option for paternity test, but I've been told that Jerry Springer does not accept Canadian guests, but Maury Povich does. So depending on how much you want to air your dirty laundry, there is always a free option there. I have yet to hear about a woman who is denying parentage, but it could happen, and that might be a good story for a Maury Povich show. If you have children and you split up, it says one of the most important things that you must do is make parenting arrangements for your children. However, I say that it is the most important thing. Parenting involves having the care and control of a child. It includes the right to have the child live with you, either all of the time or part of the time, and the right to make decisions for that child. In most cases, a child and his or her parent without custody have the right to spend time together. You must decide how and when the children will spend time with the non-custodial parent, and that's called contact. This is sometimes also called visiting rights. The purpose of access is for a child to have a meaningful relationship with both parents. Generally, the court considers it in the best interest of the child for the child to have as much contact with both parents. It's rare for a court not to allow any contact, but not unheard of either. The parent with access has the right to information unless the court orders otherwise about the health, education, and well-being of the child. A contact parent normally does not make the major decisions about the child. The court can set out specific guidelines, or it can order reasonable contact, really depending on each couple's situation individually. Reasonable contact leaves it up to the parents to work out the details. However, if for whatever reason the parents' relationship has disintegrated, the courts are able to make very specific orders that would allow for a third party to arrange for pickup and drop off so that there's limited contact between the parents. If there are family violence issues, addiction issues, there may be supervised access or limited access or restricted or no access as well. Parenting and contact orders can also be designed to protect children or bubble them from as much trauma that's occurring between the parents as possible, as well. And this is what I consider one of the most important things about parenting and contact orders, is that without an order, parenting children is like possession being 9/10 of the law. And so if one parent takes the children and refuses to return them, the police will rarely step in to get involved without an order. And so then the other parent is left with the responsibility of having to file something called an ex parte, Latin for without served notice, an ex parte order. And in order to get an ex parte order, parenting order, that person needs to convince the judge that the children are at risk and they are in need of an interim parenting order so that the police can help them to get their children back. And then, of course, once the children are safely back, then the courts would expect that there would be an application for a permanent parenting and contact order made. And again, we on our website, bearpawlegalresources.ca, it's on the bottom of all of our PowerPoint screens. We have wallet cards on how to obtain parenting and contact orders and guardianship orders as well. So check out our resources for that. Until the child is 18, both parents must contribute to the cost of raising their children if they're able to do so. This can be extended beyond 18 if the child is still needing assistance from a parent, or if they've decided to go on to post-secondary education. This can actually be extended to the age of 25 or the completion of their first degree, whichever occurs first. As well, step parents are also on the hook for maintenance as well. Maintenance typically is between two biological parents. However, just like parenting and contact, maintenance is always based on the best interest of the child. And if the child's lifestyle has become accustomed to one parent's income, including the maintenance from the non-residential parent and the income from a step parent. If that step relationship falls apart, separates, the courts will look at it as, should the child's lifestyle suffer because the parent and the step parent weren't able to get along and continue? And so, yes, step parents could also be held responsible for maintenance as well, depending on the circumstances. And this isn't just about men either. More and more men are assuming custodial care of their children, and more women are in the workforce full time. And so it's really based on both parents' last 3 years of income tax. And if both parents have shared custody, so they both are equally raising the children, then there's a formula that the courts will work out where they will look at how much each parent would be responsible solely for contributing to maintenance, and then they would deduct the lower income from the larger income, and the person with the larger income would pay the difference. And so, ladies, just know that we are also responsible for financially raising our children too. I would like to also mention that there is a 3-year expiry date. So if somebody chooses not to apply for maintenance and 10 years goes by and their child suddenly decides they want to go into hockey, that parent can apply for maintenance, but they can only make it retro to 3 years. So they can't go back to the birth of that child either. The other thing I want to say about maintenance is, well, two other things actually, is that once maintenance orders are made in court, it's not an automatic process that they're turned over to maintenance enforcement, that a person would actually have to file that order with the maintenance enforcement program, who would then assume responsibility for making sure that that they collect the maintenance payments and turn it over to that parent. So it eliminates the need for parents to fight over payments and stuff. Also, the maintenance enforcement program has the power to garnish wages, suspend and cancel anything to do with registries, so driver's licenses, registrations, as well as hunting and fishing licenses. And they also have the power to put liens on property and put people in jail. And so they do have an incredible amount of power. Also with maintenance is that they will survive anything other than death. And so if somebody files for bankruptcy and they've got $50,000 worth of maintenance arrears accumulated, they can file bankruptcy, but the maintenance arrears will survive that bankruptcy. I've also been asked if there are maintenance arrears and the parent that is owed maintenance, if they pass away, are the adult children eligible to get that maintenance. And I've checked into it, and what I found out is that no, maintenance is a contract between two parents. And unless there are underage children where they would go into care with adult children, they would not automatically have the rights to go after the other parent for any unpaid maintenance arrears, just in case that question came up. So there are four four methods that people can make parenting, contact, and maintenance arrangements. The nice way would be if parents could leave their egos and wounds at the door and sit down and civilly talk about what would be in the best interest of the child or children. And I know it is possible. And so if parents can play nice in the sandbox and come up with a fairly reasonable plan for parenting and contact and even maintenance, judges are usually pretty good about agreeing and approving orders where the conditions are reasonable. If parents can't play nice together, can't come up with a solution themselves, they can go through mediation. And as long as parents financially qualify, they can actually go through the family law office, and they can be supplied with court workers, mediators, and lawyers, free or at low cost. And mediators would then be able to be this neutral, objective third party that would try and negotiate or help the parents to come to some type of healthy resolution. In the bigger centers, we have something called collaborative law, and there are several law firms that also subscribe to the collaborative law process. And this would be where it would be like trial light, where everybody meets in a boardroom with their lawyers, their representatives, and they hammer out a reasonable deal. But a judge still has the final say. It's just a less formal and kinder, gentler process than the trial process. And of course, the parents can ask the courts to decide. Now, the problem with trials is that the only people that really benefit from a trial is the lawyer's pockets. It's usually down and dirty. It's an ugly process. And so I always encourage people that if you can set aside your own personal differences and focus completely on the best interest of the children, that is by far the best way to make it through, to survive family court and separation and divorce. If you decide that your parenting arrangements need to be changed for whatever reason, life is not static. It doesn't stay the same. And so things change. And so maybe one parent has a job opportunity where they need to travel a bit more. And so they need to give up a little bit more of the residential care. Or maybe one child has decided that they want to live with the other parent. Whatever, lots of things change all the time. And so just because you have a parenting and contact or even a maintenance order in place doesn't mean that it has to stay that way forever and ever. Amen. No. And so if things need to change on that order, all you need to do is find, and this also goes with maintenance orders as well, is find a copy of the original order, and on an application to vary, write what you would like changed, attach it to the original order, and file it with the courts. And again, for step-by-step instructions, you can go to our website, bearpawlegalresources.ca, on the bottom of the PowerPoint slide, and we have a wallet card on getting parenting and contact orders. And in that wallet card, we'll also have instructions on how to vary that order. And we also have cards on maintenance orders and guardianship orders as well. What I'd like to mention about maintenance orders is, again, circumstances happen all the time. And whether somebody's financial situation improves or gets worse, will have a profound effect on maintenance. And the other thing is that if one parent's income increases significantly, the maintenance order should vary to reflect that, because after all, it's about the children. And if you were still together, would that child not benefit from that income increase? And so it really is about best interest of the child. However, let's talk a little bit about income decreases and maintenance arrears. Before maintenance enforcement starts suspending and canceling driver's licenses and garnishing wages and really starting to get ugly, you can make an application to the courts to decrease maintenance payments, as well as decrease or rescind maintenance arrears depending on the circumstances. And so if someone gets sick and winds up having to spend a fair amount of time in hospital or whatever, or they get laid off because of COVID, who knows, right? Then those are profound circumstances. And if you were together, your family would weather the storm together. And so don't wait until all of a sudden your driver's license has been suspended or canceled. As soon as your circumstances change, make that application to the court. Don't wait. If for whatever reason the child has been taken, whether you have a parenting and contact order in place or not, I always recommend that people file a report with the police immediately, so that there is a record of when and where the children were taken, and the police have a starting place. If you don't have an order, you will definitely have to contact a lawyer, or at the very least a court worker or the family law office at your local courthouse to make an ex parte application. If you suspect that your child may be taken outside of the country, contact the Consular Affairs Bureau. And we have a parenting guidebook that has all of this information in it, and it will be soon. It's currently being updated, but it will be soon available for download and reading on our website. Again, bearpawlegalresources.ca. Grandparent rights. There is this huge mystery around what kind of rights do grandparents have to their grandchildren in Alberta. The truth is, grandparents do not have any automatic rights to parenting or contact whatsoever. The only thing that grandparents have the right to is visitation. And if there's been a significant break in that normal visitation pattern, then grandparents can apply for contact visitation. If grandparents want additional rights than that, they would have to apply for something called private guardianship. And without the parent's consent, it's a bit of an uphill battle. So you may want to consult a lawyer around that as well. The other way that grandparents can get involved is if they have concerns about their grandchildren's well-being, they can contact Children's Services and file a report and let Children's Services know that if at any time Children's Services decides to apprehend that the grandparents would want to be considered for kinship care, and that's a whole new workshop altogether there too. But just know that in Alberta, grandparents do not have automatic rights other than visitation unless they apply to the courts to become additional guardians, and that's an uphill battle. The last thing I want to talk about is adoption in Alberta. And so previously, probably about a decade or more ago now, all adoptions were processed through Children's Services, whether they were private with a step parent or another relative or a spousal adoption, didn't matter. Every adoption used to go through Children's Services. The Alberta government has since created two streams of adoption. We have government adoptions, and that is through Children's Services. And the only thing that Children's Services now processes with adoption is adoptions as a result of apprehensions and becoming permanent guardianship, children getting permanent guardianship status. Private adoptions are just that, private. And so you can contact a private adoption agency. There's lots all across the province, adoption options for one. Just Google them, they're all over the place. Significant differences, but things to keep in mind. With government adoptions, so adoptions as a result of children being apprehended, if the child is treaty or entitled to treaty status, the child's band has to consent to that adoption, or the adoption will not take place. With private adoptions, the band does not have to consent. However, I always recommend that if a treaty Indigenous child is being considered for adoption, private adoption, that the biological parent check with their membership person at their band just to check what the policies are. The whole purpose around the notification and consent is to avoid another 60 scoop situation where Indigenous children were being adopted out at a staggering rate and bands were losing track of their members. So it's really about making sure that there's that paper trail so that if in future those children decide they want to reconnect, they have that information. So with private adoption, even though the bands legally don't have to consent, there is legal conditions that state that all paperwork, all information related to the treaty status must go with the adoption paperwork, so that at some point, if the adoptive parents or the adopted child choose to reconnect or process those treaty papers, they have the information to get started on that. So those are the highlights around adoption. So that is everything that you may or may not have wanted or needed to know about parenting. Again, we have a ton of information on our website. as well as lots of resources and videos. So check us out. Otherwise, thanks for watching and have a wonderful rest of your day.